Okay, well, I'm not going to address, if they don't have a copy, I'm not going to address it because that puts them behind the eight ball because they don't have the information. But so I'm not going to address that.
I've got
So that, but in any event, that's the reason, because what they won't do is they're not going to put a tether on him where he's then going to go someplace.
So I understand that, Your Honor. What we can't figure out is I've got an email from the court in Livonia saying there's no hold. And yet a hold shows. We can't figure out what the deal is. And if you look up,
maybe present that to the jail. I'm just offering that maybe they will look at it and they'll say, well, really isn't a hold, and then put him on a tether. What are we doing on the case itself?
Thank you, Your Honor. I appreciate the opportunity for a bench conference for the record. And so we are asking that the matter be set for preliminary exam.
Discovery is complete.
To my knowledge.
And people have their witnesses available to 7. Preliminary examination in person, July 7th, 2026, 9 a.m. before Judge Perry. Bond will continue. Thank you. Sorry. Court calls case People versus Daniel Polgar.
Good afternoon, Your Honor. In also requesting permission to quote rule provision of Assistant Prosecuting Attorney Jim Kennedy.
Michigan. Permission to practice is granted.
I might have to object to this one, Judge. No objection, of course. Covered all on behalf of Daniel Polgar. Mr. Polgar, please state your name for the record.
Daniel Polgar.
And Your Honor, it's my understanding that the people we'd previously adjourned to work on the forensic interview. It's my understanding that has been complete, and we're just waiting for the video. Hence, I'm still waiting for the video downline. So we're just asking for an adjournment. I'll defer to the people as to how long they think it would take to have that ready.
You have no idea, do you? Kennedy told you to say that, didn't he? Yeah, okay. No, you're okay. July 9th, 2026, 9 a.m. Bond continued.
Thank you, Judge. Are you all set?
Court calls cases of People versus Jermaine Shaw.
Assistant Public Defender Jay Dellinger on behalf of Mr. Shaw, who is appearing via Zoom from the Washtenaw County Jail. Mr. Shaw, can you please state your name for the record?
Jermaine Lamar Shaw.
And Your Honor, may I please approach briefly with the...
Yes. Case. I guess the first thing is with reference to the competency hearing.
Your Honor, we have had an opportunity to go over the competency report. At this time, we are going to be stipulating to that finding.
Based upon a review of that report, the court would find the defendant is competent to stand trial. Specifically, the court would indicate that the defendant can understand the nature and objects of the proceedings against him and can assist in his defense. Therefore, the defendant is deemed competent, and I've signed the orders regarding that. The defendant also is going to then waive.
That is correct, Your Honor.
And so, Mr. Shaw?
Yes, sir.
All right. You're going to waive your right to a preliminary examination?
Yes, sir.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it?
Yes, sir.
All right. You understand you will not have that hearing and that you'll proceed to circuit court for further resolution?
Yes, sir.
People also waive the right. Preliminary examination having been defendant is bound over to circuit court on, where are all my people? On count 1 in each case, I think.
And Your Honor, as
all counts in each case. Go ahead.
as to that, Your Honor, we would acknowledge receipt of the information, wait for a reading, stand mute at this time.
Defendant having wait for a reading, standing mute. Court will enter not guilty plea. Pre-trial will be set for
July 7th, 1:30 with Judge Conley.
July 7th, 2026, 1:30. Bond will continue.
And then, Your Honor, just for the record, for Mr. Shaw's purposes, we
Yes, and I did sign the release for temporary release for furlough.
Okay, so Mr. Shaw, you should be released sometime today once a GPS tether is placed on you. I've spoken with your brother and you'll just need to return to the Washtenaw County Jail no later than 5 p.m. on Sunday, okay?
Yeah.
All right,
Yes, sir.
thank you, Your Honor.
All right, thank you. Court calls case, People versus Rodney Napier.
Your Honor, Raymond, look at the people.
Assistant Public Defender Donathy Lebo for Mr. Napier.
Your name?
Rodney Napier.
And Your Honor, we have reached a plea agreement in this case. However, I'm going to be asking for an adjournment in order to get the paperwork submitted.
All right, probable cause conference will be adjourned July 2nd, 2026, 9 a.m. Bond continued. Court calls case, People versus Arshawn. Is it Bangora?
Yeah.
Assistant Public Defender Zach Finney with on behalf of Mr. Bangor, who's present via Zoom. Sir, can you please state your name for the record?
Arshawn Bangor.
Thank you. Your Honor, we're requesting an adjournment to give the people the time to respond to our motion, and then I would also ask to address bond.
All right. Ms. Feltus, how much time are you going to need to respond?
Your Honor, if I could have until July the 10th.
Okay. So, and then you're going to want a hearing on this motion.
Yes, Your Honor.
So I'll adjourn the probable cause and the motion hearing to July 16th. (2026) at we do that at 3
Yes.
3 p.m.
Thank you, Your Honor.
Thank you, Your Honor.
and Esteban.
Thank you, Your Honor. Mr. Bangora is requesting to have his GPS tether removed. He has been on a GPS location-only tracking tether since I guess the end of February, Your Honor. He has been to I believe he missed one PCC date in March because he got off work late. He immediately filed a bench warrant request that day. And then got it rescheduled. He has come to every PCC since then. I believe this will be number 7. He is local to the area. He's 18 years old. And so he does have
Have other cases?
I do not believe so, Your Honor.
Any response from the people?
Your Honor, I think we had addressed this at least once before,
We did.
and I'm not sure if it was ultimately dismissed or not, but I do see a delinquency case from 2025 involving TCW. So I'm a little bit concerned to have another weapons case so recent in time.
Your Honor, my understanding at least is that that case was dismissed when he turned 18. That was what it was listed in the police report. I can verify that information though.
I think I denied this request on last.
Your Honor, I'm pretty sure. Yes, you're all discussing fighting sort of having a weapon and.
Yeah. Well, let's see where the motion comes. At this time, I'm going to deny the defendant's motion. I think bond is, or that condition of bond is appropriate in this matter.
Understood, Your Honor.
All right, so bond will continue. Thank you. Court calls case People versus Sky Freeman Jones.
Your Honor, Raymond Cook for the people.
Good morning, Your Honor. J. Grant Miller, P58658, on behalf of Ms. Freeman Jones, who approaches the podium.
All right. And where's Miss? Go ahead, Miss Fincher.
Good morning, Your Honor. Marcia Crater on behalf of Ms. Freeman Jones. As my motion indicates, there is a conflict of interest that has been brought to my attention. Requires me to withdraw from this case, Your Honor.
All right. Ma'am, you understand that?
Yes.
All right. So I'll grant the motion to withdraw. In this matter, I've signed that order. All right. Mr. Grant Miller, what are we doing on this case?
Your Honor, I met with my client yesterday, but I have zero discovery, so I'm requesting an adjournment and I'd like to address bond if I could.
Probable cause conference will be adjourned then to July 9th, 2026, 9 a.m. Yes, as to bond.
Your Honor, my client is a single mother. She has a 4-month-old and a 2-year-old at home. She lives in Inkster. She works at SCL Care. She's a in-home caregiver. She is not a flight risk. She has a very young child at home. I just would request that the court would consider personal recognizance or a very low cash bond so she can just get home to her newborn child, Your Honor.
Your Honor, this is
Go ahead.
defendant was, I believe, driver of a vehicle involved in a drive-by shooting. As counsel indicated, the defendant does have a young child. I believe that child was in the car at the time of the shooting also. So I have concerns that defendant is putting not only herself and others at risk, but specifically that child that she wants to get home to as well.
Motion for bond reductions tonight. Bond will continue. Thank you.
Thank you, Your Honor.
Court calls case People versus Laura Bartz.
People, Your Honor.
Morning, Judge. Brian Bowling, on behalf of Ms. Bartz. Ms. Bartz, can you state your name for the record, please?
Laura Bartz.
Got it. I'm asking for an adjournment for some additional plea questions, please.
No. Probable cause conference July 16th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continue. Court calls case People versus John Smith III.
Your Honor, Raymond Cook for the people.
Michael Gaddy, Assistant Public Defender on behalf of Mr. Smith, Your Honor. He's approaching.
Name, sir?
John Smith, with Your Honor.
Thank you.
We're asking the court for a very brief adjournment of this matter in order to continue discussions with the people and reach a resolution matter. If I could be heard on bond as well.
July 9th, 2026.
Thank you, Your Honor.
As to bond.
Your Honor, Mr. Smith is here. He has another matter pending, but the bond I think is $100. It's a misdemeanor larceny charge. He also has a couple of holds that I don't think they're going to want him on based on what XJ is telling me. However, this is an older file. He failed to appear some time ago, and which is all that is the bad. The good news is that in April of this year, he turned himself into the Macomb County Jail and dealt with those matters. And part of his failure to appear duration for this matter was that he spent a year in the Wayne County Jail, which he served that sentence between 24 and now.
On what charge?
It was an OWI charge.
OWI third?
Second.
Okay, so this is his third.
He is charged with a third hearing.
Okay.
He is gainfully employed. He works at Farmer John's as a butcher on the east side of Detroit over on Harper on the far east side there. He is a local resident. He stays with his family, his spouse and children at Aspen Chase Apartments. He does not drive now. He gets a ride to work from his spouse. That job is still waiting for him. Like I said, this started with him turning himself in. We'd ask the court to release him. to reduce his bond or to something minimal, or to release him on a PR bond with a scram tether. That would allow him to continue working while we're dealing with this matter and help with his family. Like I said, this matter, while there's a failure to appear, I believe that this his reclamation started with him turning himself in on April 28th at the Macomb County Jail.
Response.
Based on the notes that I'm seeing, it looks like back on June 8th of 2023, the defendant failed to appear for a PCC. The next PCC was not until August 8th of 2024, so over a year later, and he appeared in custody from Wayne County. The defendant then also failed to appear, I believe, 2 more times. One of those I will attribute to the defendant potentially being in custody in, I think it was Macomb County. But the third one was the defendant failing to appear for an exam on October 29th of 2024. Given the multiple failures to appear, I have concerns that this defendant would not show up for future hearings. And I would ask.
So it was set for exam and he failed to appear.
On October 29th of 2024, per my notes.
But the motion for bond reduction denied. Bond will continue.
Thank you, Your Honor.
Court calls case People versus Malachi Beverly, aka Malachi. There he is, I think. Go ahead.
Your Honor, Amy Lucas requesting permission to practice under Michigan Court Rules 8.120 under Assistant Public Defender Bellinger.
Oh, you got it. Permission to practice is granted.
Thank you. On behalf of Malachi Beverly, we are seeking an adjournment on the matter. You can offer, and we need time to file the paperwork.
Okay.
Oh, you say your name.
Okay, no, go ahead. Start again. No, you just, it was like I let you go. I was gonna like slow down, young pup, but you just go ahead. All right, you realized it, right? Okay, go ahead. Correct yourself.
Okay. Could you please state your name?
Sir, can you state your name?
Malachi Beverly.
All right.
Okay. We're seeking an adjournment on the matter. Just you can offer. We need time to file the paperwork.
Oh, you need time just to file the paperwork. All right. Why don't we do July 9th? Good. 2026, 9 a.m. Did you say that sounds good?
Yeah.
Like, did I seem to? Well, never mind. All right. That's the date we'll do. Bond will continue. Thank you, Mr. Beverly.
Thank you.
Court calls the case People versus Gary Thomas.
Stephanie Cannon on behalf of Mr. Thomas, who is approaching. Mr. Thomas, could you please state your name for the record?
Gary Thomas.
Thank you.
And Your Honor, we're just asking that this case be set for a preliminary exam.
Right. Discovery is complete.
Yes, to the best of my knowledge.
Requesting 911 call yesterday, Your Honor. The defendant does have another case that's set for its first court judgment. Did set this exam for that same day where it's flagged. So another child use case with the same victim. I don't see why it's not.
If I set it for the same date, you say? Do you have any problem with that?
No, Your Honor, 721 is far enough out. I believe we'll be able to get that discovery by then. Yes.
What'd you say?
No, Your Honor, I have no problem with that.
Preliminary examination in this matter will be set July 21st, 2026, 9 a.m. before Judge Moore. Bond will continue.
Thank you so much.
Court calls case People versus Richard Bauer.
Assistant Public Defender Davi Lieb on behalf of Mr. Bauer, who I have not been able to speak to.
Not checked in. He has a community corrections bench warrant for no bond in any event in this case. So we will continue the community corrections bench warrant.
Thank you, Your Honor.
Court does call the case People versus Devon Thompson.
Morning, Your Honor, Raymond Cook for the people.
Morning, Your Honor, Marcia Creech on behalf of Mr. Thompson, who's approaching.
Devon Thompson. All right.
I was just appointed on this case, Your Honor. I do not have discovery, therefore I'm asking for an adjournment in this matter.
Turn the matter to July 9th, 2026, 9 a.m.
Thank you, Your Honor.
Bond continued. Court calls case People versus Maurice Boyd.
Things are not for the people, Your Honor.
All right, Maurice Deshaun Boyd.
Thank you.
Oh, great. Michael Gaddy, Assistant Public Defender for Mr. Boyd, Your Honor. Your Honor, we're asking for an adjournment to see if we can't negotiate a settlement here or in court in county.
Turn the matter to July 16th, 2026, 9 a.m. Bond continued.
Thank you.
God bless.
Thank you, sir. Court calls case People versus Joseph Thompson.
Edward Drugas on behalf of Joseph Thompson.
And would people have their witnesses available on the 7th? All right, preliminary examination in person will be July 7th, 2026, 9 a.m. before Judge Freshour. Bond continued. Thank you, sir.
Thank you, sir.
Thank you, Your Honor.
Court calls case People versus Trayvon Bridges.
From Your Honor, Raymond Cook for the people.
No, we'll wait.
I can, Judge.
It's okay.
Assistant Public Defender. The reader on behalf of Mr. Trayvon Bridges. Mr. Bridges, state your name for the record, please.
Trayvon Bridges.
Thank you.
Thank you. Your Honor, we're asking for an adjournment in this matter. I was just on the phone with Mr. Bridges. But we just, one last conversation and we'll have a resolution.
What? You tried to sneak one in? You seriously?
I think he does it on purpose.
Hold on, Bridges. Don't worry about it. You're okay. Why'd you try to sneak it?
I think he does it on purpose.
Does it? Oh, this was for the one, oh, like a long while back. Okay, so take that one. I think the file might be gone already on the shelf. All right. You want an adjournment on this one, right?
Judge, please.
All right. I'll adjourn this one to July 6th, 2026, 9 a.m.
Take care.
All right. Thank you, sir.
You're welcome. Have a good day.
You too. Court calls the case of the People versus Christina. Is it Eichard?
Good morning, Your Honor, Marcia Creech on behalf of Eichard. She's on Zoom, Your Honor.
Could you state your name, please?
Christina Joe Eichert.
Thank you.
We are in receipt of the competence evaluation. It's my understanding my client has been found competent to stand trial, and we have no objection to the report and request the court to set a proper cause.
We'll also stipulate to the report. All right. Based upon the report, the court would find that the defendant is competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent. Counsel, I'll need an order
Okay, thank you.
today. We'll need it.
Yes, absolutely.
All right. I'll set probable cause conference in this matter then for July 9th, 2026, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court calls case People versus De jure Bond Sanders.
Alexander on behalf of the people around. Stephanie Cannon, on behalf of Mr. Bond Sanders, who is approaching, Your Honor.
Your name, sir? Deja Bond Sanders. Thank you.
Your Honor, we're asking that this matter be set for preliminary exam. In addition, when appropriate, I would like to address bond.
Discovery is complete.
Yes, Your Honor.
Go ahead. Their witnesses available the 7th. Preliminary examination, July 7th, 2026, 9 a.m. before Judge Perry. As to bond.
Your Honor, I have provided the prosecutor with an order for release to treatment. And my client has a substantial drinking history and drinking problem, which I do believe contributes a great deal to why he continues to be before the court. It's my understanding that I believe they're going to object, but I do have the order for
People what?
I believe they're going to object to release to treatment.
Go ahead.
Joe Kowalski was calling the victim. The court is well aware they revoked his bond and his phone calls, but the last week told the victim as he was leaving court, she wasn't present, that he loved her in the courtroom. And then after he got back to the jail, he then made one more phone call to her, he said he blocked her number. So I'm given that while he is in custody and not drinking, he still can't follow court orders.
Anything else, Ms. Me?
Again, Your Honor, I do believe a lot of this just stems from his substance abuse and some mental health problems that he and I have discussed. And in this case, I think to prevent the revolving door that is him, treatment is going to be our best option. And I'm just asking that we be allowed to start it.
I'm not going to sign it. All right.
Understand?
Okay.
Yes, the same.
CourtCase case, People versus Donovan Buckner. Yes.
People in your eyes. This is public defender.
To not be chair, I can't really, Your Honor. Donovan Buckner. Judge, I have not been able to make contact with Mr. Buckner.
Oh. If I walk real slow and talk real slow, you Buckner. Nope. Bench warrant will issue for defendant's failure to appear bond 10,000 cash surety. That warrant will issue immediately.
Thank you.
Court calls the case of the People versus Justin Heaton.
We're going to do it for this people, Your Honor.
However, on behalf of Mr. Heaton.
Sir, your name?
Justin Heaton.
Thank you. What are we doing?
Your Honor, I was just appointed yesterday, so I am asking for a brief adjournment for discovery and plea negotiations. I'd also like to make a bond argument when the court finds it appropriate.
Has he been, all right, well, I'll adjourn it to July 9th, 2026, 9 a.m. Before you go about addressing bond, has he been assessed? Has there been a CMH assessment?
May I ask if that's part of bond?
Pardon?
May I ask that happens as part of bond so that it's all wrapped up into one?
I was just asking. I thought so. So you want me to prepare an order so that you can have a CMH assessment? Is that okay?
Yes, so that I could.
I thought that was already arranged, but apparently that didn't get done. So I need an order that the defendant should be assessed by CMH because his bond at the last bond hearing or at the last hearing, I said I would reconsider his release once there was an assessment.
Understood.
So at this point, bond will continue, but get that order into me.
I'll prepare that order today, Judge.
They did mention that we could handle that after outside of
Yeah, I know what I got that. There are two ways of doing it. And I just wanted it done this way. All right. All right. And Mr. Burdell, you're aware of just so that we're clear of the housing issues.
It's been brought to my attention, yes.
Okay.
I'm still up to speed on it, but it has been brought to my attention.
Got it. Okay. Thank you.
Judge.
Courthouse case, people versus Jalen Carter.
Ashley Bashir on behalf of Jalen Carter.
Oh, my goodness.
Hi.
Hello, long time no see.
No, yeah, I'm happy to be here. But unfortunately, I have not been able to get in touch with Mr. Carter.
So you're here after not being here and you don't have a client.
I'm very sorry.
And know what?
I
More and more like Chinasa. No, go ahead. All right.
I do have a green sheet, but I was going to request an adjournment or an opportunity to get in touch with him. So possible delay before a bench warrant if one is issued.
Do what?
I was going to ask for an adjournment or as an alternative, 48 hours to get in touch with Mr. Carter.
They've got you in Ann Arbor, don't they?
I'm in Chelsea and Saline.
You're what?
I'm in 14A3 and 4 now.
Oh, are you? They do that out there?
I'm not sure yet, actually.
Yeah. Oh, so you just got to Chelsea.
Yeah.
You were in Ann Arbor.
Yeah.
Because this is very much an Ann Arbor request.
But
Bench warrant will issue for the defendant's failure to appear. All right, I'll give 48 hours. Bench warrant will issue 29th.
Thank you, Your Honor.
You're welcome. Nobody else gets that. Or calls the case, people versus Clarence West.
David I. Goldstein appearing on behalf of the defendant.
Your name, sir?
Clarence Alexander West.
Yes, sir.
Your Honor, I do have written discovery in this matter. There are videos, I believe, that I have not. Are there videos? If so, if we can just have a week so I can goes.
All right. Probable cause conference will be adjourned to July 2nd, 2026, 9 a.m.
Your Honor, what do you show as this status bond?
Bond. I have a PR in case. Yeah, I have a PR.
Your Honor, he has a PR bond here. He also has a case in Wayne County in which there's PR, and yet they're holding him. We can't figure out why.
Was our PR conditioned on a tether?
Was?
You were supposed to get a tether.
Okay, that may be the problem then.
Well, no, it shouldn't be.
I also know he has the old.
Yeah, at a Wayne County that's been taken care of.
I have Van Buren and Livonia back, right?
Livonia, the Van Buren is, we appeared there and they said a PR bond. There is nothing in Livonia. We called the police department, we called the court, and there's nothing there.
I checked extra as of yesterday, but I don't know if they don't.
No, I've got it. I've got to know
that, but in any event, that's the reason, because what they won't do is they're not going to put a tether on him where he's then going to go someplace.
So I understand that, Your Honor. What we can't figure out is I've got an email from the court in Livonia saying there's no hold, and yet a hold shows. We can't figure out what the deal is. So anyway,
I don't. Yeah, no, I got you, but I don't know that there's anything I can do to try to
go to Livonia,
fix that. But I think you have something from the
court
indicating that there is not a hold.
Right, and if you look up,
maybe present that to the jail. I'm just offering that maybe they will look at it and they'll say, well, really isn't a hold, and then put him on a tether and release it.
We'll try that, Your Honor.
All right.
Thank you.
Thank you. If I adjourned it to the second. Have you been presented the letter? Okay, so once you guys have that, even if you fashion an order for my signature to present to the jail, I'll do that if upon review of that. Okay, if that'll help. Court does call the case, People versus Rodney Clark.
Select Gunner Doc, you leave both for Mr. Clark, Your Honor.
Oh, I'm sorry. Not sure.
He is not checked in.
Oh, Your Honor, I did speak to him after I would ask the court to consider passing the matter.
Bench warrant will issue for defendant's failure to appear.
Thank you.
Fine, 10,000 cash surety. Warrant will issue immediately. Court calls the case, People versus Benlea Winter.
People. Oh, defender on behalf of Benlea Winter.
Oh, I'm sorry. Ms. Winter is approaching.
Your name?
Correct.
Leo Winter.
All right. Just competency hearing. I have the competency report. Is there anything additional from the parties?
No, Your Honor, people stipulate to the report.
Mr. Getty, you.
Yes, Your Honor, we would.
All right, I would stipulate that the report indicates that the defendant is competent to stand trial. Court would indicate that upon review of the report, the defendant can understand certain objects of the proceedings against her and can rationally assist in her defense. Therefore, the defendant is deemed competent, and I've signed that order. What would you like me to set this for?
We ask for
At a probable cause conference for July. Is this the only case holding her? No, you got something.
I have a PR on the other one, sorry.
There's a PR on your other case?
Sure.
Well, there's a.
I'm seeing look like there's 2 out of 1. There's one thing, one punch, that's fine. The girl one's just a traffic offense, but the Novi one is drug related.
I reached out to Novi. I sent them a letter. And
Pardon?
I reached out to Novi personally. I sent them a letter. And they just sent me back a letter by itself. I plan on going, if I get released, to handle that.
And as far as the county, Your Honor, we've seen that there is an illusion. The 14B, like process.
Out of 14B.
That's what actually.
Well, what I'll do is I'll adjourn this to the 9th, 2025, or 2026, I'm sorry, 9 a.m. I will. You have 25,000 cash surety because there was. It usually indicates to me that there's.
Looks like there was a bench warrant in this case, Your Honor.
Yes, and I'm not. Oh, that's why.
I was seeing psychiatric help during the time, I think, around of this. I completely forgot about this incident.
Okay, hold on a second. Okay. I don't need you to go into detail, but where are you with your mental health treatment?
Honestly, I didn't get the correct mental health services until I came here. I was involuntarily withheld a couple of times at Havenwick Hospital, and they gave me meds that weren't working. Here, I was able to work with a psychiatrist to find medications that help, and I've been on medication, yes, since March.
Since March.
Yes,
Okay, and you're continuing on those medications now?
absolutely.
Okay,
Okay.
hold on a second. That was in March of this year?
Yes.
Anything else regarding this defendant's bond?
Yes, Your Honor. Ms. Whitner.
So if you're ahead, you're gonna talk?
What?
Go ahead.
Sorry, Your Honor.
Thank you.
I'm sorry.
No, we're waiting.
She does have people in the community, she has a brother and a sister who live in Ypsilanti. But as can't continue with CMH as reported, she's working with the reentry program. There is a pharmacy that's already been identified on Michigan Avenue that can fill her prescriptions. And they've made arrangements for her meds to go there on.
I could have issued this like an hour ago, but it's okay. Go ahead. I'm listening.
Nothing further.
Thank you. Motion for bond reduction is granted. I'll set your bond at a personal recognizance. $25,000 bond. Just make sure you show back up. You hear me?
Sure.
All right. Thank you.
I don't win off in your.
No, it was a brilliant argument. Court case, People versus Tommy Lee Clark Jr.
For the people here, Stephanie Mann on behalf of Mr. Clark. You should be appearing by Zoom. Mr. Clark, could you please state your name for the record?
Clark can't appear via Zoom.
I'm sorry, Your Honor. Mr. Clark, could you say your name?
Tommy Clark.
Your Honor, we are requesting an adjournment in this case. My client was released yesterday. I didn't have the opportunity to speak with him. So we're just asking for an adjournment.
Got it. Okay. So what were you asking for?
An adjournment?
He's got to get himself, because he's out right now. He's got to,
He got out yesterday. Yes, Your Honor.
needs to get himself to community corrections. I have a violation report because they didn't show that he was in.
Oh,
I know.
okay. But Your Honor, he was in. Mr. Clark,
I know that.
okay, you need to come to Washtenaw within the next 24 hours and meet with community corrections, okay?
All right. Okay. So I'll adjourn this out to the 16th, July 16th, 2026, 9 a.m. On continued. Thank you. Court calls for the case. People versus Benny Sims.
Allison, on behalf of people.
Assessment Blood Found about leave on behalf of Mr. Sims. And it looks like he's appearing by Zoom from the jail, Your Honor. Mr. Sims, could you state your name?
Sims, they're calling your case.
Mr. Sims?
The judge is calling you, Sims.
I must be in person. My attorney told me that. I know he's.
All right. All right.
They're calling your case.
Well, that is Mr. Sims. What are you trying to do on this case?
Your Honor, I was going to be setting it for a preliminary examination, please.
Okay. Discovery is complete.
It is, Your Honor.
People have their witnesses available the 7th. All right, preliminary examination will be set for July 7th, 2026, 9 a.m. before Judge Fresh Hour.
Thank you, Your Honor.
On Sims. Court calls case People versus Vincent Freeman II.
Allison, on behalf of people, Your Honor.
Michael Gaddy, Assistant Defender on behalf of Mr. Freeman. And
Vincent Freeman II.
yeah, we'd like to set this matter.
All right.
If I could be heard.
Discovery is complete.
Yes, to the best of my knowledge, Judge.
People have their witnesses available the 7th. Preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Perry.
Your Honor, if I could be heard on bond.
Yeah.
Yes, Your Honor, Mr. Freeman is obviously here. There's 3 holds. They're traffic. I don't think there's things that they're going to pick him up on. The bond is currently set at 10,000 cash. He is, the complaining witness do not reside together. He resides in fact, in Detroit on Ellsworth, and reports that he can return to that address where he's lived for the last 5 years. So I don't think there's any issue in terms of physical contact between the two of them. There are bond conditions, including a GPS tether that could be used to track his location so that there is no concern over, well, so that the court's any concern about contact would be elite. And the court more reassured that he would comply with any reasonable conditions the court sets.
Rounds.
Okay, Jackie, I do have this about, that he had 3 calls made today after his brain with 2 being complete from his pen. So I don't think he can follow court orders. I do also have concerns given that this is a case where he punched out the front windshield and back windshield of her car with his hands and then resisted officers. And I believe he'd be a danger to be given that he can't follow conditions while in custody as well.
Yeah, I have not heard those calls. So
Motion for bond reduction denied. Bond will continue.
Thank you.
Court does call the case People versus Deborah Collette.
Assistant Public Defender Zach Green with on behalf of Ms. Collette, who should be present via Zoom. Ms. Collette, can you please unmute and state your name for the record?
Can you pass this back?
You got it.
Court does call the case People versus Tyrese Pitts.
Morning, Your Honor. Raymond Cook for the panel.
I'm sorry, Your Honor. Attorney Sharon Jones, P number 57113 on behalf of Mr. Pitts, who is in the jail approaching. And Mr. Pitts, if you could please say your name.
Tyrese Pitts.
Your Honor.
Sorry. Yes.
Thank you. Today is the date and time for the PCC and also for hearing on a bond motion I filed that is regarding a funeral. We are asking to set this matter for exam.
Is discovery complete?
It is, Your Honor. It appears to be complete.
People have their witnesses available the 7th.
Yes, Your Honor. We'll do about it.
All right, preliminary examination will be set July 7th, 2026, 9 a.m. before Judge Freshour.
Your Honor, if I may, the co-defendant's case was also set for exam that day before Judge Perry. Would it be possible to keep these 2 cases together? It would be the same. Oh,
Yes.
thank you.
We'll do that. So the co-defendant's already been sent before Perry.
That's correct, Your Honor.
All right, so we'll make this before Judge Perry. And then as to bond, did you?
Your Honor,
Go ahead.
a family member died and the
Yes,
funeral.
go ahead.
I believe my client's family member's funeral is tomorrow. So he is asking that he may be allowed to attend his loved one's funeral and say his last goodbyes.
I don't. Any response from the people? I don't know. Did you get a copy of this motion?
I do not have a copy of, there was a written motion filed. I do not have a copy of that. I'm checking because I saw on the docket, it looks like it was a motion set. I did not see one in our file nor in my court, so I was unaware of what exactly the motion was. Regardless, I would be objecting to any change or release at this time. This is a case where defendant, along with a number of other individuals, were fleeing from police and what I believe ended up being a stolen vehicle after a shooting out of county that 120 miles an hour on the highway past them on the right, going through the red lights. When police eventually found the defendant after they fled on foot from that vehicle, he was hiding in an apartment. I would also note that this defendant has numerous prior convictions that give me reason to believe that he is a danger to the community. I'm seeing as far back as 2016, I believe. There's a felonious assault. I have convictions for, excuse me. Scroll down. CCW, receiving, concealing a motor vehicle, malicious destruction of police and fire property. One, 2023, felon in possession of a firearm. 5, it looks like. There's another conviction, or sorry, no, those were just found over. I don't know what the disposition of those charges are, so I'll leave those off. But 2026, the defendant has a fleeing and eluding in third degree, as well as a recent CCW conviction. So I have concerns that this defendant proves to be a flight risk as well as a danger to the community. I sympathize with the defendant of the loss of a loved one, if I don't believe that release is appropriate at this time.
Your Honor, and my client currently is not facing any type of charges alleging that he fled from police. My understanding is that the arrest was in an apartment building or apartment complex.
After they got out of the car and ran to it, and the police followed them there. I realized they may not have charged that, but
Well, Your Honor, all I can say regarding the charges is that my client disputes that, but this is his last chance to say goodbye to his brother. And it would seem to me that if he could have some sort of escorted opportunity to attend the funeral, that
And you're just for some additional context as far as the firearms involved in this case, pursuant to a search warrant, police received a box of Hornby 40 caliber ammunition, an AR-15 magazine, an AK firearm with a double magazine, an AR-15 rifle with a magazine and shell catcher, an AK hell pup with a magazine, a Glock 17, a 40 caliber Glock magazine, a 9mm Glock magazine, and a Glock 22 handgun.
all right. I'm not gonna let this, I understand and I feel for the defendant, but I'm not gonna allow release at this time. His bond will continue. Thank you.
okay.
So much is
Thank you. I'd also filed a motion for a team member to go interview Mr. Pitts at the jail.
for who?
An investigator? I think I submitted a proposed order just for them to be able to visit him at the jail to do an interview to assist me because of the volume of discovery.
I don't have a copy of that motion either, so I'm not able to.
So I don't, counsel, I'm not, you gotta send a copy of your motion to the prosecutor's office, because this is now the second one that that they don't have for whatever the reason.
They're in the email. I sent it to your court and to the prosecutor's office. Both.
She did what?
Prosecutor's office.
So you sent it to the generic email for the prosecutor's office, didn't get a name?
I sent it to the only email I had for their office.
Okay, well, I'm not going to address, if they don't have a copy, I'm not going to address it because that puts them behind the 8 ball because they don't have the information. But so I'm not going to address that motion. All right, thank you.
Thank you, Your Honor. May I ask, do I just send it to the prosecutor that just spoke? Is that the correct individual at this point, or would it be a different prosecutor since it's before Judge Perry now?
Ma'am, you can send it to me and I can give you my email. Once we're off the record, I can shoot you an email because I believe I have your email.
Okay, thank you. I would appreciate that.
Thank you.
Have a good day, everyone.
Court case, People versus Danina Combs.
Brian Bowling on behalf of Ms. Holmes. Can you state your name for the record, please?
Danina Holmes.
Your Honor, I'd like Ms. Combs to be screened for entrance to the recovery court at the court level. So I'm asking for an adjournment to do that. I will, before I submitted the referral form, I wanted to get the next court date, so I haven't done it yet, but it will go out shortly.
You think you can get that accomplished by the 16th, or you need more time? Or we're gonna.
I would say probably better, from what I hear, that maybe go a little further into July if possible.
The 23rd or 30th, which one would you like?
Let's do the 30th.
All right.
They decide.
So I'll adjourn to July 30th, 2026, 9 a.m.
Perfect. Thank you.
Thank you. Bond continued. Court does call the case People versus Wilnisha Crosby.
Assistant Public Defender W. before Ms. Crosby, who appears via Zoom.
She's been dropping. She's not in. I'll pass it.
Thank you, Your Honor. She is currently in treatment.
Okay. Court calls case People versus Vasquez Davis.
For the people.
Have a basket, David.
How you doing today? My name is Vasquez Davis. How you feeling?
I'm doing all right. How you doing?
Man, my day be better if yours good.
What'd you say?
I said my day would be better if yours.
What started as an ordinary court docket quickly turned into a mix of humor, tough decisions, and second chances as defendants stood before the judge hoping for favorable outcomes. The hearing opened with a light-hearted exchange between attorneys and the judge, who joked about lawyers keeping him waiting and playfully teased them about their cases. But once the proceedings got underway, the focus quickly shifted to serious criminal matters, including assault cases, probation reviews, and defendants facing possible trial dates. One of the day's most important moments involved a defendant who was being held on a parole hold while awaiting resolution of a criminal case. Defense counsel argued for a reasonable bond, but the judge declined to make changes until more information became available, emphasizing the need to fully understand the parole situation before taking action. Later, the courtroom saw a stark reminder of the consequences of missing court. When one defendant failed to appear for a scheduled hearing, the judge immediately issued a bench warrant and set bond at $7,500, making it clear that attendance in court is not optional. The mood shifted again when a young woman recovering from serious injuries explained that she was unable to work while pursuing disability benefits. Rather than immediately penalizing her for financial struggles, the judge listened carefully and created a manageable payment plan, encouraging her to stay in contact with probation officials. The hearing ended on a positive note when another defendant successfully completed the requirements of a deferred prosecution agreement. After paying his remaining balance and finishing the court-ordered conditions, the judge dismissed the case and discharged him from probation, offering a final message of encouragement as he moved forward with his life. By the end of the day, the courtroom delivered a powerful lesson. Show up, follow the rules, and take responsibility, and the court may be willing to give you a second chance.